So today, good evening to all of our students and our faculty members here. We are glad that we are starting our session on international arbitration and the career aspects for professionals in India. Since so many students from Maharishi Universities have joined us today, it is first of all very important for all of us to know that international arbitration is not a career that is restricted just to the lawyers. It is a career aspect that is inclusive of, lawyers, engineers, CAs, MBAs, and various other technical professionals. So it will be a very interesting and informative session, especially for other professional people apart from the lawyers who are not much aware of this field and are looking forward to make a career into it. So as we start, in the recent years, international arbitration has evolved into a preferred mechanism, for resolving cross-border commercial disputes. As international trade, investments, and cross-border collaborations become more frequent, the need for neutral, efficient, and enforceable dispute resolution method is more critical than ever. Arbitration has stepped into this role, and enforceable dispute resolution method is more critical than ever. Now, arbitration has stepped into this role and is offering various parties from different legal systems a platform to resolve conflicts without going through prolonged litigation. For Indian professionals, particularly those in the legal and the corporate sector, this field presents a world of opportunity. As India continues its journey towards a global economy, Indian businesses are engaging in international contracts that often include the arbitration clauses. With this shift comes the increased need for professionals who understand both Indian laws and the nuances of the international arbitration practice. Now, the career potential in this field is very vast and multidimensional. One, important avenue is the working as arbitration counsel. Many of the India's top tier law firms have robust arbitration practices and frequently represent clients in international proceedings. These firms often collaborate with international legal teams, giving young Indian professionals a chance to gain global exposure early in their career. Another exciting path is becoming an arbitrator. While it takes years of experience, credibility, and often cross border exposure to reach that position, the demand for neutral arbitrators with an understanding of Indian commercial realities is growing. The rise of Indian arbitration centers like the Mumbai Arbitration Center, then we have Bangalore International Arbitration Center, Delhi International Arbitration, and also International Economic Forum of Commerce and Industry. That includes the ICAM, that is International Council for Arbitration and Mediation. So there are various institutional such arbitration center, and today we are just making you aware of the institutions that are in India. And apart from it, there are international global forums like ICC in Paris, Singapore International Arbitration Center in Singapore, London Center of International Arbitration in London. These are the global international arbitration centers and the most sought after because the level of international arbitration in other countries, especially Singapore and London, has grown so high that India has to compete very fast. So, competing with these countries and making India a hub for international arbitration, it is important for all you students who belong to management, belonging to other fields like engineering sectors and even lawyers, that you can choose international arbitration as a career. For example, if there is a construction dispute, then there would be a lawyer who is qualified as an international arbitrator. They can be a retired judge, and there will also be some very high professional relating to the engineering field who has also the qualification of arbitration, who can assist, as a technical expert in the arbitration of construction related matters. So that was one example. Apart from it, there can be medical dispute, there can be forensic disputes, there can be, marine disputes, shipping relating issues. So there are huge scopes that is growing into this arena, and this scope is not just restricted to the corporate lawyers or the law graduates, but also to people from other professional fields. Many multinational companies and Indian conglomerates have in-house legal teams dealing with contract drafting, arbitration strategies, and enforcement of both. Corporates, they don't go for litigation, they always choose arbitration. And since corporates are big MNCs and branches across, they go for international arbitration. So, how to make a good career in international arbitration? That's a very important question. For the lawyers, the first answer is you can pursue a particular LLM into the international arbitration. This LLM can be from a good foreign university. It can also be from an Indian university. But if this LLM is inclusive of only domestic arbitration, we will not be, entitled to be an international arbitrator. So you have to look into the syllabus and also the tie-up and collaboration of your universities, that what syllabus the LLM is inclusive. If the LLMs, your syllabus includes the international arbitration laws of New York Convention, the UNCITRAL model laws, the UNCITRAL laws that is taught by the international arbitration centers like the CIR that we are going to discuss ahead, then your LLM is definitely going to assist you gain a good reputed law firm or be qualified as an international arbitrator. Now, certification courses are also provided by the Chartered Institute of Arbitrator London, that is recognized worldwide and is one of the best prospects, and it is the most widely accepted center for attaining the qualification of international arbitration. And my being a member of CIR, I would say yes, this helps you get accredited across the country. So you can go for the associate courses, the membership courses, the fellowship process. Apart from it, other centers like the Singapore one, the Bangalore centers, the Mumbai, sometimes they can design their exclusive, courses to admit people to make them international arbitrators. Even International Economic Forum of Commerce and Industry, our forum. As a president, we are also launching various courses, associates, and members grade to make people aware about what international arbitration is, organize various workshops, make people first of all aware of it, collaborate with universities to design good LLM courses to introduce international arbitration at par with Singapore, and also, take up and hire arbitrators and mediators as our counsels and arbitrators in our center. So there's one, area and aspect through which international arbitration can be improved in our country. But slowly and gradually, we can see that how far people they are becoming more, aware about this career aspect they are, and they are, you know, they all are seeking how to join such centers. Now, what are the career aspects? There is opportunity to work in international, organizations, the treaty-based bodies, the institutions like UNCITRAL laws, the World Bank, the ICSID, the International Center for Settlement of Investment Disputes, then the PCA, the Permanent Court of Arbitration in The Hague. All the lawyers must have learned that it's a international, centers. Then professionals are there who are designing these treaties and frameworks. There are high impact roles, especially for those with expertise in public international laws, investor state disputes, and treaty negotiations. Then there are so many universities like Singapore National Universities, Hong Kong, in India, the national universities that are giving you LLM courses. Now, next is the policy and advisory role with the national government and the think tanks. Another avenue professionals can work on international arbitration law. Like the Niti Aayog is there, the Ministry of Law and Justice, the legal policy research organization like the Vidhi Center for Legal Policy are playing a crucial role. So their aspect is not just restricted to arbitration practice, but how to design a good arbitration law. Because domestic arbitration differs a bit, apart from the basic, procedure remaining the same, but there would be some structural differences, some procedural differences, and we have to know the differences between the domestic laws and the international laws. So these are the forums that are working with the ministries and the government on the policy designing and the future, designing of such arbitration laws in our country. Now, as we are speaking on the career aspect, and since we are also having the team of students who are not from the legal background, I will just throw light on the basic procedures of what international arbitration is. International arbitration generally follows a structured, predictable, and party driven process. It begins with the arbitration agreement, often embedded as a clause in commercial contract. This agreement outlines how disputes will be resolved, whether under the institutional rules like those of the ICC, Singapore, or London, or under ad hoc frameworks such as the UNCITRAL arbitration rules. The UNCITRAL arbitration rule developed by the United Nations Commissions on International Trade Laws. These rules are designed for ad hoc arbitration, meaning they are not administered by any institution unless the parties agree otherwise. This gives the parties more flexibility and autonomy in how the arbitration is conducted, particularly useful in commercial disputes between the parties from different legal backgrounds. Now, first adopted in 1976 and later revised in 2010-2013, the UNCITRAL rules provides a comprehensive procedural framework covering certain important aspects. Now, that is appointment and challenges of arbitrators, conduct of proceedings, interim measures, hearing protocols, issuance of the final award. One key feature of these rules is neutrality. Neutrality means the judge is a neutral. The arbitrator has to be neutral. Whatever is the jurisdictions, whatever countries are there, the arbitrator has to be impartial. You can't be partial to one country or another country. You have to maintain the neutrality. They are crafted to accommodate both the civil and the common laws traditions, which and why they are popularly known as international, commercial, and investor state arbitration. What does this sentence mean? For lawyers, you may try and understand, but for other, it is important to know that when you are entering Singapore, so there would be the Singapore International Arbitration Center. Singapore International Arbitration Center will have its own law. Singapore International Arbitration Center. This law will be applicable to the parties in the dispute. Now, supposing an Indian company and a Singapore company, they come across a dispute of 100 crores. Now, this dispute, they have decided the jurisdictions or the seat to be Singapore. Now, Singapore is the seat. Singapore, may we all are going to have this arbitration. Now, when we choose a jurisdiction, such places also include their own common law or the civil laws. So such tradition or such arbitration laws are designed and framed in such a way that their own civil laws will not be infringed. That will also be considered back. Because once supposing the International Arbitration Center has given an award, now the question comes, can we challenge them back to the court? Supposing you're not happy with the award, supposing Delhi may be conducted an international arbitration center, the award says 50 crore has to be paid by company A to company B for the losses they have incurred in this contract or in the violation of this contract. Now the award say the parties are not happy, they can go back to the court, they can challenge it in the Supreme Court, they can challenge it in Delhi High Court depending on the amount of the dispute or the jurisdiction, they can challenge it back in the court. So, whenever international arbitration is dealt, we have to consider even the civil laws of the country. Civil laws of every country may vary, the Singapore, London, etc. So that is, going into the in depth of it. When you people start studying on the ancestral laws, the New York conventions, or other laws relating to the international arbitration, your interest will also be increased into it, and your knowledge regarding how the things happen, how you challenge it back, how you question it back, that will also be clarified to you. Now, many investor state disputes under the bilateral investment treaties for the free trade agreements also use the ancestral rules, particularly in proceedings under the auspices of the Permanent Court of Arbitration at Hague. For Indian professionals, understanding the ancestral law is essential not only because of their frequent use but also because India itself has been engaging in treaty arbitration under the rules. Now, once a dispute arises and arbitration is initiated, the next step is the constitution of arbitral tribunal. As I already said, we have chosen Singapore in our example. Parties usually appoint one arbitrator. They can be two arbitrators. They can be three arbitrators as well. It entirely depends on the agreement clause. This composition is vital that the tribunal has to be impartial. It has to have the expertise. The efficiency should be there in the outcome of it. Then there is a timetable given it. It's not like litigation that will go for 20 years. If we decided that within a year we have to resolve, we will try and complete it in the time frame. So that is the huge difference between the arbitration thing that happens and the litigation that happens. Now, hearing is also a stage when oral arguments will be there, where the examination of witnesses will be there, presentation of documents and expert evidences will be there, physically, virtually in a hybrid form, sometimes even through the video conferences, especially in the lockdowns, arbitration happen. So this way also it can be conducted. Once arbitration key strength is that awards are enforceable in 170 countries under the New York Convention, making it far more efficient than trying to enforce foreign court judgment. So once 170 countries they accept New York Convention, it will be more easier because 170 country dispute will be settled out in these 170 countries and we can follow the New York Convention laws. So there won't be any dispute that we should use the particular country's civil law or we have to use the Singapore law or we have to use particular convention. The New York Convention has been accepted by 170 countries, so comfortably the jurisdiction of the 170 countries can be chosen for the disputes in international arbitration. We discussing that now it is comfortable to come up into and find the jurisdictions because of the New York conventions and such treaties. Now, understanding the procedures is crucial for professionals, whether you're a lawyer drafting arbitration clauses, a counsel arguing cases, a policy advisor reviewing treaties, or even a business leader navigating contracts. It is not only gives you clarity on how disputes are resolved, but also deepens your ability to anticipate legal risk and add values in global legal environment. Now, to conclude with, international arbitration is no longer a peripheral or specialist domain. It has become a cornerstone for global dispute resolution, driven by the increasing complexity of cross-border commercial investment flows, internationally, regulatory frameworks. For Indian professionals, the career landscape in this field is rapidly expanding, and not only within the traditional roles such as arbitration counsel or arbitrator, but also across newer interdisciplinary domains, involving policy advisory, legal tech, third-party funding, academic research, and international institutional. With Indians, active participation in global trade and its commitment to strengthening the arbitration ecosystem, the legislative reforms and institutional development professionals from India are uniquely positioned to contribute meaningfully to this space. Now, however, success in this field will depend not only just on the academic credentials or legal training, but on a deeper understanding of the procedural systems. Unlike the ancestral arbitration rules, a readiness to work across jurisdictions and legal cultures, and a commitment to continuous learning. The path may be competitive and demanding, but it is equally rewarding, both intellectually and professionally. Those who invest the time to build relevant skills, cultivate networks, and gain international exposure will find themselves not only practicing in this field, but also helping define its future direction. Now, ultimately, international arbitration is about more than resolving disputes. It is about facilitating global cooperation, safeguarding investment, enabling fair and efficient commerce between the parties who may never meet face to face. It is about trust, neutrality, and professionalism. I believe Indian professionals have the knowledge and resilience and global outlook to excel in this domain as this field continues to grow and evolve. I encourage you all to see yourself not just as a participant, but as a future leaders, educators, innovators in international arbitration. Thank you. Thank you and best wishes to all the students from Maharishi Universities who have joined our podcast in the webinar today, and especially the engineering students who are very keen and excited. We will certainly have more such webinars and sessions for engineering and the MB students to tell them more on the construction arbitrations, the maritime arbitrations, and the arbitration fields that is relating to the engineering sector, because that's a ever evolving and the growing field, and more engineers they can join into it and they can become arbitrators. So thank you for the day.